There was also a part of this decision which limited the use of evidence by prosecutors. And that was noted not just by me, but certainly by Amy Coney Barrett, a Trump appointee to the Supreme Court. Here is what she said. Before I quote her, the holding was a bridge was too far for her. She argued that, quote, the Constitution, of course, does not authorize a president to seek or accept bribes, yet excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution. Professor McCord, as a former prosecutor, would you walk us through what prosecutors need to establish to successfully secure a conviction and exactly how this prohibition on evidence in the Trump versus United States case would prevent prosecutors or harm their efforts to do so?
Yes, a prosecutor, of course, to prove any criminal case must prove beyond a reasonable doubt every element of the offense charged. And to do that, they introduce evidence into court that establishes those elements and argue to the jury that the elements have so been proven. By hamstringing a prosecutor, even in a prosecution that the Supreme Court has now told us is possible, a prosecution for unofficial acts, purely personal acts, by barring evidence of official acts in those prosecutions, that severely hamstrings the government, as Justice Barrett pointed out in her dissent to that part of the court's opinion.